Mr. Secretary General, ladies and gentlemen, I would like to express my gratitude to the OIC for the invitation to contribute to this very important meeting. Unfortunately, due to a previous commitment, I'm not able to be in Jeddah during this time. But I appreciate the opportunity to say a few words by video, and I hope that we may engage in person in the very near future. Religious intolerance is a real issue, one that deserves a concerted effort to address. In doing so, I submit that it is crucial for us to be guided by and only take action that is compatible with the whole corpus of the human rights framework, especially Article 19 of the Universal Declaration of Human Rights and the International Covenant on Civil and Political Rights, and Article 20 of the Covenant. Resolution 1618 was a landmark achievement for the diplomatic community. It opened space for global commitments to address religious intolerance through promoting the related rights to freedom of expression, freedom of religion or belief, and non-discrimination. This fifth meeting of the Istanbul Process marks another important opportunity for, as the concept note aptly put it, a frank exchange of views. Almost 4 years after this important step within the United Nations, so much remains to be done to ensure that the commitments expressed in Resolution 1618 are translated into reality. In some critical cases, we can even see a deterioration of the space for freedom of expression and religion. It is, of course, impossible to consider these issues without noting acts of violence undertaken in the name of religious belief. Just as the year started, the tragic episode of the killings in Paris shocked the entire world, with murders of cartoonists and of individuals shopping in a kosher market. In the space of the last couple of months, 3 bloggers were killed in Bangladesh for advocating against extremism and for tolerance of diversity in belief. What can be done in response to these violent situations? If we look at 1618, and if we look at human rights norms, the responses must not lose sight of the fact that free expression is central to deterring hate speech. It is critical that responses not go beyond the requirements of Article 20 of the Covenant and stay well within the limits of what Article 19 permits. Unfortunately, despite international commitments, the responses of various governments to episodes of violent extremism continue to be misguided, and they include disproportionate sanctions that are frequently used not to combat incitement to violence, but to silence criticism and political expression. In this connection, the Rabat Plan of Action deserves our consideration. Developed after a very intense consultative process in 2013, the Plan of Action provides a comprehensive roadmap for tackling the most serious forms of intolerance and hatred, considering the roles of state and non-state actors. Some of the recommendations from Rabat are relevant and must be given careful attention. These include the call for states to repeal blasphemy laws, which are often used to repress religious minorities and unconventional thinkers, not to protect religious believers. The call for states to adopt comprehensive anti-discrimination legislation, and the call for states to ensure that criminal sanctions related to incitement should be seen as a last resort measure to be only applied in strictly justifiable situations using the least intrusive means possible. It is also worth recalling that human rights law provides for the prohibition of incitement, not mere advocacy, to discrimination, hostility, and violence. I especially want to urge us all to make the most use of non-legal tools to combat discrimination and promote understanding and tolerance. This includes educational measures and openness and protection to combat hatred and enable space for all religious belief and expression. Implementing these recommendations, particularly when they relate to revising and adopting national norms, can only happen if there is good dialogue channels at national and international levels. Rushing the adoption of laws without proper consultations is never a good idea, especially on these challenging matters. Again, this meeting will certainly be a good opportunity to share experiences in this regard and to identify what can be done to ensure mistakes committed in the past are not perpetuated in future legal reforms. To conclude this brief message, I would like to once again highlight my determination to continue working closely with the OIC and all other stakeholders in the follow-up to the Resolution 1618 and in the global debate on discrimination, freedom of expression, and freedom of religion. My predecessor took an active part in various debates leading to Resolution 1618 and the Rabat Plan of Action, and always had the OIC as a key interlocutor. This will continue to be the case in my work. Thus, even though I am not present in Jeddah today, I look forward to hearing the results of this meeting and to further cooperating with the OIC and its members and all the stakeholders in this room in other important activities you will be developing in this regard. Thank you very much.